I want to welcome Betsy Steger to the podium first. She is the social services attorney for the Chautauqua County. She focuses a great deal of her emphasis on the Medicaid area. The second segment will be a tag team between James Grasso and Marty Idzik. They're both partners at Phillips Lytle and deal in the management of the private and public sectors in the law and employment law areas. The third segment will be Kevin Hogan, also a partner at Phillips Lytle, concentrates his practice in the areas of environmental law, intellectual property, and litigation. And the last segment in this first 2 hours will bring Mike Lamancuso from the McLean Group, and he will introduce Dennis Roberts, the chairman of the McLean Group, who has joined us today. So we'll start with Betsy Steger. Welcome.
Nothing so far away from Woodstock than Medicaid, so let's rock. I'm going to talk about long-term Medicaid issues. There have been a lot of changes in the past couple of years, and my assumption is that anybody who's truly interested in that topic probably has some basic background in the Medicaid program, so I'm going to skip over that and just sort of deal with what's changed recently. The biggest change that we dealt with came in 2005 with the Deficit Reduction Act, which increased the look-back period for Medicaid transfers to 5 years. And as of February 8th of this year, we are now at the full 5-year look-back period. So every application from this point forward, all transfers made within the 5 years prior to the application will be reviewed, whether they're into a trust or not. The penalty period that gets imposed if there is a transfer for an uncompensated value is changed as well. It used to begin to run as of the date you made the transfer. As of now, and as of 2006, it runs either the date you made the transfer, the first month after the date you made the transfer, or the date on which the individual begins receiving nursing home care and is otherwise eligible for Medicaid, whichever is later. So basically, at this point, if you've made a transfer within 5 years before coming in to apply for Medicaid and it's uncompensated, the penalty period, which will prohibit you from having Medicaid pay your nursing home care, will be imposed beginning the date you can qualify for Medicaid and be in a long-term care facility except for that transfer. So you have to be otherwise eligible. It becomes very critical then to be thinking about your timing as to when your application is going to be made, and if you're trying to get past the 5-year look-back period, making sure that you've calculated the resources correctly and calculated the look-back period correctly. You determine the penalty period by dividing the uncompensated value of the transfer by the Western New York region nursing home rate, which is currently $7,863. In the back of the materials, there's a ADM or GIS message, I think it is, that gets issued every year that changes that number. So the current one is in your materials, but if you're working with a client, you need to look that up each year because it does change every year. In 2006, there was also a change in annuities. If you purchase an annuity, you can actually purchase an annuity anytime before you apply for Medicaid, as long as it's actuarially sound. You don't have to wait 5 years. However, now, if you purchase an annuity or take other action related to an annuity that was purchased even before February 8th of 2006, you are required to name the state as the beneficiary of that annuity. If you have a community spouse or a minor child or a disabled child, you would name the state in the second position as beneficiary. If none of those exist, the state gets named in the first position. As I said, that it's supposed to be for annuities purchased after February 8th of 2006. However, if you've taken action on a previously purchased one, such as adding to the principal, elective withdrawals, changing in the distributions, or elections to annuitize, those trigger this provision as well, and you'd have to name the state as a beneficiary. More recently, there's been a limit on the Homestead exemption. When someone applies for long-term Medicaid and they're in the nursing home and they own their own home, they can sign a statement of subjective intent that they are going to return to their home, which would allow them to maintain or keep their homestead while they're in the nursing home. The department would file a lien against it. However, we wouldn't take action on that lien, or they wouldn't be required to use the value of the house to pay for their care as long as they had subjective intent. And there was no value limit on that house at the time you signed it. It didn't matter what your house was worth. Now that's changed, and currently the only amount that's exempt is up to $758,000. Anything over that will be counted as a resource. Chautauqua County, in practical matters, that's probably not a big issue for a lot of us, but I suppose there are a few houses that are probably worth more than $758,000, so it could come up. Purchases of loans, notes, and mortgages, another vehicle used to attempt to shelter your assets in order to make you eligible for Medicaid, has been to buy a note or a mortgage and take the income back, and those are okay as long as they are actuarially sound, that the note requires equal payments, and that there's no deferral or balloon payment, and no termination of the obligation upon death of the applicant recipient. A lot of times what people used to try to do is they'd buy a note or mortgage and have the obligation to repay terminate on their death, so that way at least some balance of the money was transferred to their relative. Can't do that any longer. The note has to provide that the full amount has to be repaid, and obviously the amount would then become an asset of the estate of the applicant recipient when they pass away, and the department would have a claim on that. You can purchase a life estate in someone else's home. However, in order to do that and make it not be considered an uncompensated transfer, the applicant recipient would have to have resided in that home for at least 1 year prior to the purchase. So if they've moved into their son's home and they want to buy a life estate, in that home they can do that. However, they have to have lived there for a year, and it has to be based on the fair market value of the life estate value. So you have to look at the life expectancy of the applicant recipient and make a determination about what the fair market value of a life estate would be for them. More recently, and I didn't put the years in here because it just sort of begins to all mush together for me. You've always been able to use some of your funds as an applicant for long-term Medicaid to buy burial space items or set up funeral accounts. Generally, we see that with the applicant or recipient setting up the account for themselves or their spouse. There's also been the ability to do that for other family members, such as your children, your sisters and daughters-in-law, and brothers and sons-in-law, and grandchildren. Not many people took advantage of that. It used to be that it could also be a revocable burial, but now if you're going to use funds to establish burial accounts for family members, it has to be irrevocable, and it can only be for burial space items. If the applicant recipient is doing their own funeral account or their own account for their spouse, you can have the irrevocable account for burial space items. You have up to $1,500 for additional burial expenses. That's not the case for the family members. It's just burial space items, and you need to do it in an irrevocable trust with the funeral home. The state has eliminated the requirement in the Medicaid programs that an applicant come in for a face-to-face interview. All of the applications now can be determined based solely on the paperwork submitted. We cannot require anyone to come in for a face-to-face interview in any of the programs, whether it's long-term care or community Medicaid. But for those applying in the long-term care program, our experience has been that it's more helpful to come in for an interview, and they can request an interview. There's an awful lot of paperwork that has to be submitted. There's a lot of material. You have to go back 5 years and pull in a lot of material about your resources. And if you're simply doing it by mail, a lot of time gets lost and wasted as we're sending mail back and forth. You send something in, we send you back a letter telling you still need more. So while we can't require the face-to-face interview, and if you're working with a client who's attempting to get long-term Medicaid, it might be worth your while to ask for a face-to-face interview so you can sit down and at once get the full list of everything you need to submit rather than going back and forth. In the community Medicaid program, the state has eliminated the resource test. It used to be for all Medicaid programs, to be eligible, you had to meet a resource test and an income test. They've now eliminated that for most community Medicaid programs. Resource test still applies to long-term Medicaid, and it still applies to someone who's SSI related. So if you're SSI related, it's a $2,000 resource limit. And then for long-term Medicaid and community Medicaid as well, for an individual, the limit is $13,800. So your asset limit has increased as well over the past several years. But long-term and SSI are the only ones with the resource test anymore. When we used to have the penalty period run as of the date you made a transfer, attorneys often talked about doing a rule of halves, where they would talk about gifting away half the resources of their client to family members and keeping half to pay for Medicaid during the penalty period, and then be eligible for Medicaid after that. That, because of the change in when the penalty period takes effect, that doesn't work. But now there also is a new thing out there called personal care contracts. And we're seeing a lot of attorneys establishing personal care contracts between their client, the applicant or recipient, and a family member. Basically, they're giving a lump sum of money to the family member, and in exchange, the family member is agreeing to provide personal care to that person. The state has decided that we can allow those, and you can still be eligible for Medicaid if you have such a thing in existence. However, it has to be in a written agreement. The agreement has to be specific about the care that's being provided, because one of the things that has to happen is we have the ability to make a determination as to whether or not the cost for the care that's being provided is at fair market value. Because if you're asking someone to, as an example, come clean your house, and that's the care that's going to be provided, and you're planning to pay them $5,000 a month, the county might object that that's probably a gift, more so than a fair market value exchange. So it has to be in writing. You have to be specific about the care that's being provided. The purchase or the price or value for that care has to be fair market value. The agreement has to provide that any prepaid amounts given to the caregiver must be refunded if the caregiver at any time is unable to complete the contract. And any money not used must be returned upon the death of the applicant recipient if they die prior to their life expectancy. So if you're setting it up for fair market value, not only does it have to be fair market value of the services you're purchasing, but you have to establish an actuarially sound agreement so that during the life expectancy of the applicant recipient, they would receive the full value of the services for the full amount of the money that was paid over. In the 2011-2012 budget bill New York State just adopted, they've changed the definition of estate. When an individual receives Medicaid on or after their 55th birthday, or while in a nursing home, the state has a claim against their estate for correctly paid Medicaid. There are only certain times when we can recoup correctly paid Medicaid, and one of them is from an individual's estate. The budget bill now changes the definition to include jointly held property, retained life estates, and interests in trusts. I've been watching an interesting email battle between the private bar and the county DSS attorneys arguing about who's going to get the ear of the state first to help them draft the regulations that will implement this provision. For those of you who are in the private bar, congratulations, you won. The state had a meeting already with the private bar to get their position, and then the local DSS attorneys are still working on getting their position into the state. But we're still waiting for regs on that, but that does expand the definition of an estate and as to what assets the department can take a claim against. And in March of this year, the New York State Court of Appeals, which is, I think the decision is also in your materials, decided the case of Balzerini. When you have a community spouse and an institutionalized spouse, we budget for the institutionalized spouse through the spousal impoverishment rules. This allows the community spouse to retain a certain level of income, which is called the minimum monthly needs allowance. It also allows them to keep a certain amount of their resources above and beyond the exempt resources. Exempt resources are things such as their homestead that they're living in and one automobile and several other things, but above and beyond that, they are allowed to keep additional resources. one of the issues is always, what about the community spouse who has expenses on a monthly basis higher or greater than the minimum monthly needs allowance? And there's always been a provision that would allow them to ask for additional income from the institutionalized spouse, or to ask to be allowed to retain assets to create income to bring them to the minimum monthly needs allowance, or to take them beyond that if they had a reason for additional expenses. Balzerini has just ruled that regarding the increase in the minimum monthly needs allowance for a community spouse, there must be exceptional circumstances, which is more than just the necessities of daily living. They're not entitled to necessarily maintain their prior lifestyle. So a family or a couple who had a fairly extravagant lifestyle and have a fairly high income, a large part of that income is probably going to have to be used to pay for the nursing home care. And someone will argue that the community spouse should be entitled to keep the additional income or even assets to create income because they have perhaps high credit card bills, they have a high mortgage and other expenses that they're paying. And basically the court has said that that's not enough. It has to be something that's beyond the control of the community spouse, that is unexpected, that they couldn't have planned for. But simply the fact that you have lived a more extravagant lifestyle isn't sufficient while you're asking the taxpayers to support your spouse in the nursing home. So there's going to be a lot of ramifications for that, and I'm sure there's going to be a lot more attempts at the private bar to try to get around that. But the legislation also at the federal level over the past couple of years has affirmed in terms of the income for the community spouse that the counties can apply what we call the income first rule. If the community spouse needs additional income to get them to the minimum monthly needs allowance, and the institutionalized spouse has income, we can deem that institutionalized spouse's income as available to the community spouse to bring them to the minimum monthly needs allowance before they can ask for or receive additional resources to create income. So there was some confusion about that over the years about whether or not we had to allow them to keep the resources, but the federal law has changed and made it very clear that the income first rule can apply, so that the community spouse is going to get all of the income of the couple up to the minimum monthly needs allowance before we'll begin to apply it to the nursing home care of the institutionalized spouse. Things that haven't changed over the years that we still see quite often are life estates, individuals coming in to apply for Medicaid who have a life estate in their own home. It doesn't count as a resource at the time of application. However, if they sell or lease it during the lifetime of the life tenant, it must be sold or leased for fair market value, and that does count either as income or as a resource for the ongoing care of the individual. We also see supplemental needs trust being used a lot, not only for long-term care, but also for community Medicaid, in particular when somebody who is disabled has gotten an inheritance or received funds from a settlement in an accident or a personal injury claim. Very specific rules about supplemental needs trusts, about what needs to be included. If you're thinking about doing that, you should make sure you're reading all of the regulations, because it's very particular about what needs to be in the supplemental needs trust. But the other thing to think about is, because, as I said earlier, community Medicaid, if you're not SSI related, has no resource limit. You may now want to consider whether or not the individual truly does need a supplemental needs trust in order to maintain their Medicaid eligibility, or whether they can maintain the resource themselves. And I think that's a fast trip through, but that's probably it. Do you want to do any questions or not? Anybody have a question?
Betsy, what are you going to do about a case in terms of an applicant owning a note when they sold the farm and
Well, in the first instance, we're going to look at that as, if it's not actuarially sound, we're going to have to consider it a transfer of some value, depending on how you...
The transaction had nothing to do with Medicaid.
Well, what I was going to say, though, is that we would look at it in the first instance as a transaction that was not for fair market value based on the rules. However, the individual could always request a fair hearing and make the claim that they made the transfer for reasons other than to apply for Medicaid. And that's always been in the rules, that if you can establish that you made the transfer for reasons other than to apply for Medicaid, it doesn't matter if it's actuarially sound, we're stuck with the transfer.
But the applicant then has to prove it.
Correct,
Presumption is not fair.
correct.
So from Chautauqua County's point of view, we're going to be going to a fair hearing on that.
Probably. Unless you can convince the parties to modify their note. But if it turns out that I sold the property for fair market value, but I'm taking back a note that isn't going to give me the fair market value during my life expectancy, then the part that you're not getting back is the part that's going to be considered the uncompensated transfer. Anybody else? Okay. I got you close to back on time.